a motion?
Motion.
We have a second.
I'll second it, Mr. Chairman.
We have a motion, we have a second. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Does publication meet all of the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
Motion.
We have a motion, and we have a second.
I second.
All those in favor signify by raising your right hand. Passes unanimously.
The purpose of the Board of Adjustment and the conduct of this meeting. The Board of Adjustment, the BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into the evidence and made a part of this record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and the arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development orders for site plan approval are final unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the board. However, if an applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions or any aggrieved party as defined by state law may seek review of any such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter appeal to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete the blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until one of these completed request to speak forms is completed. We must have the completed forms for the public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13. Before a decision by the board or on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. The first case is case number conditional use 2023. Board members, has there been any knowledge or information obtained from ex parte communication or any visit to the site? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are a party to this item please come to the podium and identify yourself at this time and state the name and address of your residence?
Thank you, Mr. Chairman. I'm Buddy Page, Professional Growth Management Services, LLC, in Pace, representing the owner of the property and the application before you for consideration this morning.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And were you, Mr. Page, were you furnished a copy of the staff's findings of fact?
Yes, sir.
And you understand that all the criteria must be met in order for the board to grant a variance?
I do.
Since it was a positive response from staff, would you like staff to make a presentation, or would you like to go ahead? And
Either, whatever is the pleasure of the board.
that might be quicker if we do it.
I could do it? Sure.
Let's let the staff do it.
Staff will do it, okay?
Good morning. Andrew Holmer, Escambia County Development Services. This is conditional use KCU 2023-07. Here we have a location map. This is a 500-foot radius zoning map showing the zoning on site is MDR. And as you can see, this is in that area that is somewhat mixed as far as jurisdiction, City of Pensacola to the south, east, and west. The future land use for the site is mixed-use urban. This is an aerial map of the site. This was taken prior to clearing that has happened since then. There was a minor subdivision on site, and 4 houses are now in where it has since been split. You can see immediately adjacent to the east, you have a townhouse subdivision there. 300 feet to the west, it's just off. This view is an apartment complex. This is public hearing sign posted on site. This is looking north into the subject property. Looking northeast into the subject property. And looking northwest into the property. And in those you can see the brand new construction that has gone on. 2 lots on either, or 2 houses on either side of what will be the entrance to the townhouse development. As to the criteria, in medium density residential, townhouses that are not among the permitted uses of the district are a conditional use, which brings us here today. Specific criteria. Criterion A. This deals with general compatibility. This project is located in an area of mixed single-family lots, including townhouse subdivisions and multifamily developments. These residential uses are compatible with the purpose of the MDR zoning district, and this request would also be compatible with those surrounding uses. Criterion B, facilities and services. Adequate facilities and services are available in the area and will be connected during the construction phase for the infrastructure. Criterion C, on-site circulation. Ingress and egress will be via Tony Street as depicted on the submitted site plan. Criterion D, nuisances and hazards. Nuisances and hazards are not anticipated with this proposed residential use in an existing residential area. Criterion E, solid waste. Solid waste service must be provided and reviewed at the construction plan stage. Screening and buffering is criterion F. Screening and buffering are not required between residential uses. Criterion G, signs and lighting. Any signage for the use will need to be reviewed and permitted through the county. Exterior lighting will need to be directed inward. Criterion H, site characteristics. The site appears adequate to accommodate the proposed townhouse subdivision. Criterion I, use requirements. The LDC does not provide additional use requirements specific for townhomes. As the findings, staff recommends approval of the proposed use as requested.
Mr. Page, would you like to add anything to that?
Mr. Chairman, I would. I would add that this particular block of Tony and Lanier and Sanders and John Carroll, outside of the lot that the applicant wants to continue to develop, just to the east of it, your aerial did pick up the fact that there are 18 townhouses right next door, common property line, adjacent on the east side. I don't think what it did not show, and you can see on this aerial here, there are 3 lots just to the west. If you would have gone one more lot, you would have picked up 20 townhouse units that face on Sanders Street, still within the same block that this application is the subject of. And then if you looked at the northwest corner, there are 2 different projects there, 2 different duplex units, which is certainly a form of multifamily type housing units. So, Mr. Chairman, I would emphasize that what this request is asking to do is no different than what is already fairly present in the block all the way around, especially in the fact that it has the same units right next door adjacent to the east that the applicant wants to build on his property adjacent and to the west, Mr. Chairman.
Thank you, Mr. Page. We have a couple of speakers. We may call you back, Mr.
Thank
Page.
you.
I think these are all. Carrie Bishop.
Gary is still, is engineer's back and forth, so.
He would like to not speak.
Okay. It'll be noted that he's in favor of the proposition. Likewise, Jessica Ford does not wish to speak and is in favor of the proposition. Okay, we have a speaker, John Delmar. Please come to the podium and be sworn.
Hello, my name is John Delmar, and I appreciate the opportunity to speak.
Yes, sir.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
This, I think, is the first time that, I know it's the first time that I've seen what has been proposed on this property, and that's one of the main reasons that I am here. It looks like there's maybe a dozen townhouses planned for this, approximately an acre. I own land which is directly north of this piece of property, yes. And I live directly north of that. What they have said is true. There are townhouses in that in this area, but this is an old area, and I wonder if it was not zoned at the time and you could build what you wanted to, because that area was that way. I plan on retiring on the north side of that. And that just looks like a lot of traffic, a lot of people. And yes, there are other projects like that in the area that's been completed, and we've got enough of them. So if it's got to be developed, I would prefer to see single family housing go in like they did on the front side. And I wouldn't have any problem with that, and I don't think anybody else here would. Directly on Tony Street there is, that whole street is just nothing but residential, single family residential. That would be to the south of them. That roadway's not made for more people than what's already traveling on it. It appears to me, and I'm not an expert. But when they talk about the common property to the east of it, there is, I forgot how many units they said, 18 maybe. But if you look at the aerial from that, there's only a few houses in that area, and it can accommodate that much traffic. And I know that's just one of the things you look for. But this street here, the people that's on it, it's an old neighborhood. People have big lots. This piece of property is kind of personal to me because I was raised on it. It was family land. And I plan on retiring right north of it. So I know that doesn't matter, but that's just too much. That's just too much for that area, considering what else has been there. And that's a good point. There are others there. And there's basically, in my opinion, too many, because I've seen them all. I've lived there for over 40 years, and I've seen most every one of them built. And it has changed the neighborhood, and we just want to keep it like it is.
We
And that's
appreciate your
about all I got.
participating
I appreciate it very much.
in this. Just a second, please. Just in case the applicant has any questions of the speaker. Our staff, do you have any questions of the speaker?
Just a comment for everyone. Townhomes are not multifamily. Townhomes are single-family development. With a townhome, you own land, the land under the building. There is a common parcel around it, but townhomes are single-family. It's a single-family subdivision.
Okay, and I certainly appreciate that because it brings a point. They are connected, though.
Yes, the buildings are connected.
What is the difference in the land requirement for, what is it zoned now?
Medium-density residential.
Okay, and we're wanting to change it to medium density?
No, sir. This is not a zoning change. Conditional uses are uses. Every zoning district has uses that may be a little more intense than some of the others in there.
Okay,
So they require approval through this board. So it's not changing the zoning at all.
okay. But it would change, something's got to change in order for this to happen. A
What they're
conditional
requesting
use.
is that, yes, sir, the conditional use would be to allow townhouses.
Okay. If, as it's zoned right now, do they have a minimum square footage or frontage requirement for homes? If it
So,
was just homes like they built up front?
right, so the way that works, this common parcel that this is gonna be included in, just same way as the ones immediately to the east. There, you have individual lots included within a common parcel. That common parcel has to meet the roadway requirements out front.
Okay.
As you can see, let me see if I can pull the plan up on here and zoom in. Can you zoom in?
Board members, any questions of the speaker?
We're gonna show him the frontage.
Okay.
If you could, sorry, I know it's difficult to. Go to right, no, down to the street. There you go. So at the street, you can see that the common parcel these are included under is 81.33 feet. Medium density requires for a new lot along the right-of-way for, it says 80 feet at the street right-of-way for townhouse groups, et cetera, et cetera. So it meets that requirement for the roadway frontage.
Okay, and that's fine. I guess what I'm saying, what I was trying to get to, is that what the conditional use change is for the developer is that they want to put more housing, more homes, individual homes that are connected, townhouses or whatever you call them, on that property. And that's the issue I have. I think that's too much.
Okay?
It's, like I said, if you do, and they are correct, there are a lot of townhouses in that area, but a lot of these are very old, and I know, because I lived there, that area was unzoned, and you could do anything within, like building or
Correct.
businesses or whatever, before it was zoned. And it's been zoned a certain way for a long time. And
Since
I know
the
things
90s.
change. I know things change, but with that being said, that's just gonna be too many people, in my opinion, to accommodate these people that live on Tony Street. Also, something that probably needs to be brought up, and I know developers, you know, I'm sure that they've made this so that it's a separate piece of property, separate development. But with that being said, and there'll be somebody speaking later, that these 4 homes that, I don't know if they're all sold or not sold, but I think some of them are sold, the 4 homes that were just built. Nobody had a clue there was going to be a dozen townhouses behind them. And so I don't know if fairness enters into this with your decision or not, but I believe that if I was to have bought one of those homes, I certainly would have wanted to know, but not being an expert, I wouldn't have known to ask that question. What do you plan on doing with the back of it? Because the homes, I do know, are either finished or close to being finished, and the next phase starts. So, you know, was this, you know, maybe there should have been a little bit more disclosure. But at any rate, that's all I've got to say at this point, so I appreciate y'all very much
Again,
for
we
listening.
appreciate your input. Board members, any questions of this speaker? Seeing none, thank you.
Thank you.
And this number of units does meet the density requirements of medium-density residential.
Thank you, sir. Diane, is it Squizzo? Did I butcher that? I'm sorry.
You did great.
Please raise your
Hi.
right hand.
State your name and address.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead and state your name and address, and you may begin.
Diane Squazzo, 1701 Tony Street. I'm directly across from the properties that we're here for today. I had the pleasure and luxury for over 50 years of looking at 2 acres of beautiful wooded area. My neighbor died, children sold the property, I understand. Several months ago, I was able to meet the contractor and her dad. I saw them out front when I was going to my mailbox, and I asked her what their intentions were, and she said, to my knowledge, she said, we're planning on building 4 houses. I said, are they going to be low-income habitat? And she said they were going to be very nice residential houses. She says her and her dad have built houses in Pensacola, and very, very nice high-end houses. All the neighborhood was very, very pleased with what they were building. And I said, okay, that'll be good. When the building started, there were 2 houses and 2 houses, and I noticed a wide area in between, and I'm going, well, what's going to be there? And I spoke to one of the gentlemen who was working on the property, and he said that, I said, what's this for? And he said, well, the contractor is trying to get permits to build 4 more houses back there. I figured, well, okay, that'll be okay, 4 more houses. So I thought that's what was happening until I got my little blue card that said townhouses. Like Mr. Delmore had said, this is a very quiet residential, lots of houses. We don't need townhouses. I mean, I spoke to I don't know if any of the people, I met some of the people who bought those 4 houses, and I don't know if any of them are here. I know some of them are still out of town, but 3 of them said to me, had they known that there were going to be townhouses built, but they never would have bought the houses. I'm concerned, as a senior citizen, I'm concerned about safety. With 12 or 16, how many is supposed to be projected? 12? Okay. I don't know what kind of townhouses they're going to be. I'm concerned about the traffic, like Mr. Delmar said. I'm concerned about the safety, just everything. Our little neighborhood has been beautiful, and we just don't need townhouses. That's all.
Board members, any questions of the speaker? Nope. Applicant, any questions of the speaker? Staff, any questions of the speaker? Seeing none,
No, sir.
Thank you very much.
Thank you.
Jeffrey Gutton didn't say if he wanted to speak or not. Jeffrey, did you want to speak?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, state your name and your address, okay?
Jeffrey Griffin, 1709 Tony Street, Pensacola, Florida, 32504. One of the reasons why I'm against the frat house is the 6 brothers down the street, and I don't want people to have access. I don't want there to be more drinking and stuff, because then it could lead to more accidents on the street, and it could lead to people could die earlier from different type of cancers and stuff. And so I'm just totally against the frat house, because I just don't like what it could create, and I think it should be a regular house and stuff. And I think, I know it would cost more to build and stuff, and I would want it to be built with all brick, all slab, and with a regular AC and stuff. So, thank you, have a good day.
Thank you very much. Board members, any questions of the speaker? Seeing none. Vieta Griffin.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name, address, and you may begin.
My name is Lietta Griffin, 1709 Tony Street. I'd like to oppose the building of the townhouses on Tony Street. The first thing is because the roads and the infrastructure is not built, not good enough to accommodate. We have 12 units, 12 cars at least, driving down our road. The risk of flooding, as you all know, we're in a high area, 95 feet above sea level, but the risk of flooding in there is very bad. And I also suppose on my card it said to allow townhomes in medium density residential zoning. I was sent this, but other members have gotten the thing that it said is designated as a frat house. Now, we all know what a frat house designates. That's right, alcohol. So from there, the safety of the people that live on this block is of issue. So that I just don't think that it would be a good idea. Thank you very much for your time.
Thank you.
No.
Staff, any questions of the speaker?
The frat house case was last month.
Right.
It's not this one. This one is townhouses.
It's on their card.
Can we have one of those,
Can we have
please?
one?
I'd love, yeah, thank you. Apparently, some of them did have the language from last month's case. How would the board like to proceed?
I would like a statement from the owner, the developer, that is in no way intended.
I'd like to know what the county designates, what the county can allow as a frat house.
Is there any way, and I know it's time consuming, and I know a lot of people took off to come here today, but is there any kind of way that the correct information can be sent out and we can take a look at this again and hear it again? That way, no one from the community is confused about the situation.
Board members, if that is the desire, we staff don't mind, and because of that area, if that's the case, we would definitely pay for it, because this is definitely not a frat house. The zoning is completely different. To have a frat house, you have to need a different zoning, but we want to make sure for the purpose of having, my name is Horace Jones, by the way, I am the director, and we want to make sure that the public is aware. But if that's, we can proceed with that, or we could just continue with the case with the understanding that this is definitely not for a frat house. This is for a single-family townhome development. There's a distinct difference between what is proposed and what this is. So this is definitely not a frat house for college campus. It is not.
Mr. Chairman, I'd be concerned, and I don't know if the developers shares that concern, but apparently proper notice wasn't given.
Yes.
And that would seem to me to be an appealable error. And I don't think it'd be wise to proceed with a proceeding where you know that notice wasn't given properly to parties entitled to potentially contest the action.
I agree with that, Mr. Chairman. If it's respectable to the board and to you, Mr. Chairman, I would like to make a motion for the county to go ahead and take care of the expenses of making sure this is properly advertised, making sure the community has clarity on what's going on. And I know that, you know, things have, you know, like the developers and stuff, I know they have dates that they would like to meet, but it's only fair for the community and for the developer, for everybody to have, you know, clear communication before they come here and, you know, about this case. So if I can make a motion at this time.
And I'd like to add before you make that motion, I do strongly, first of all, I want to apologize. Mistakes do happen. That's we are human, we do make mistakes. But, Mr. Kirkland, you are definitely correct. It's only right so that the public, because this is a quasi judicial hearing, and we don't want there to be, as Mr. Godwin stated, any grounds for anything to be appealed because of this technicality. So it definitely was a mistake, and mistakes do happen, not making excuses. Thank you for bringing it to that attention. And again, if that is the wish of the board, staff strongly want this to be correct going forward. And it happens, and we do apologize for that error.
Can I make one comment before we go on the motion, is that, you know, we have the ability to put limitations on our conditional use. And,
That's true too as
you know,
well.
And it is pretty easy, since we know that this mistake is because we had a frat house hearing last month, that, you know, adding to the conditional use that it cannot be a frat house seems like a way to get rid of that problem, and move forward, because if we can do that.
Mr. Chairman, I think that the problem isn't, that would be, I guess, in a way, a fix, but that's not the issue. The issue is notice. Notice was improper, and us assuming that we would do something like that, you've not, in my opinion, cleared up or corrected the notice issue. It's still appealable, in my humble opinion. Mr. Page also, he is representing the developer. He has the right to speak on this, and I think he should have the opportunity, if he wishes, before the board takes any action.
I thank the board for their time and troubles. It's deeply appreciated. Thank you.
Thank you. Yes, sir.
Mr. Chairman, the purpose of these meetings certainly is to have an opportunity for the applicant to explain what they want to do, and for the public to come forward and question any questions that they might have in those terms. The position of the board at that point is to answer those types of questions and take any action that they certainly deem necessary. Questions come forward. We've already heard them about traffic. We've heard them about capacity of, I guess, water and sewer. And this is the type of forum where the correct information then is put forward for the board's consideration. We were unaware that the language in the notice had that information on it. But again, it's the board's opportunity to correct anything, whether it's on our application or whether it comes from the public or whether it comes from the staff. I don't think, in my opinion, I don't think if we delayed it and simply re-advertised it and took those two words out, we would come back in here again, and at that particular time, we'd go through the same thing, I'm guessing, that we're going through here today. I would suggest, and I think it would be in the interest of the applicant, to make a decision today about adjusting anything that the board might see fit to do, and take a vote. You have taken a look certainly at the staff's analysis, all 9 of the items that are in the application. The staff seem to find each one of those to be favorable, and it's the board's decision then to either agree or disagree with points that are raised at that meeting or at this meeting. I would hope that the board would be able to look at what has been presented here today and say that information was erroneous in the advertisement, and we're here today to strike those items from the record of this meeting and move forward with a vote today, Mr. Chairman.
Mr. Page, you are absolutely correct. The board will have that discretion. Things can be made, but this has to go before the DRC committee. It has to be approved by the Board of County Commissioners. At that time, more citizens can show up at the final plat, at the final plat meeting. When it, because this, oh yes, because see, the final plat got to come before the Board of County Commissioners for approval if wants to go through. This is a townhomes or a final plat. They got to be approved by the Board of County Commissioners. And at that time, more citizens can show up. It'll be the final plat discussion, not this. You understand what I'm saying? So to be cleaner for staff purposes, to be cleaner, they can make corrections, yes, but to be cleaner, notification, the Board of County Commissioners, they take that very seriously. They really do. So that's just my concern as staff.
Just to clarify, we've looked at this, looking into this. There was approximately 90 mailers went out, so approximately 22, roughly a quarter of those had the wrong language, the rest had the correct language. But they did go, some of them did go out with the incorrect language.
Yes, that's a good point, Drew. Thank you.
So the concern, even if we correct it by eliminating that use in our conditional use, is that because of the notification, improper notification, an appeal is possible. And
I would
so we
defer to your legal counsel.
Yes, that could raise a due process issue.
Yeah, so we would be better off delaying to make it cleaner.
Any other discussion on this? We have a motion, we don't have a second yet.
Do we have
Could we get the motion?
Could we restate the motion?
with a date, the next month's meeting or something on?
I'd like to make a motion that proper notice be sent out to the community, and this be heard on our next meeting next month,
June 21st.
June 21st.
And staff will pay the notice. And staff will pay for the notice since it was an error that
And
was made.
staff will pay for the notice and whatever cost is involved in this next hearing.
I'll second.
We have a motion, we have a second.
Yes.
Do we have any comments at this point, board? Those in favor signify by raising your right hand.
And I do want to say, now that doesn't mean that staff finance is going to change. It's just a correction for the notices. Want to be clear. That's the correction for the notice, because that is definitely an appealable action as our attorney stated.
And the minutes should reflect that the motion was made by Willie and seconded by Ross.
It was seconded by me.
Oh, I'm sorry. All those in favor signify by raising your right hand. Passes unanimous.
Thank you.
Go to our next case. The case is closed.
Well, does this affect,
Chairman, I have a member from the public who requested to speak on the case that'd like to make a general comment. Would you like to allow that?
they want to speak?
Or do you want them to wait until next month?
They need to be here next month.
Well, if they wish to speak, I don't think there's any harm in that.
Go ahead and do it
Sure.
today.
Well, I mean, we are here at a public meeting, so if he, as a member of the public, wishes to
Okay.
speak and he signed up to speak.
All right.
Do we have a sheet?
You
Yes,
filled
he
out a
did.
blue
He
sheet?
did. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
My name is Andrew Rains. I live at 1516 Tony Street, Pensacola, Florida, 32504. At this moment, I'm very, very proud of y'all for the decision y'all made, and let me explain why on a personal note. I have the honor of serving our state on three different appointed boards by the governor of this great state, and have been confirmed by the state senate. Numerous times, y'all, I've mentioned this publicly, numerous times when the Attorney General's office comes and speaks about the Sunshine Law, unfortunately, our county is put down. I hear it at almost every meeting that the Sunshine Law is discussed. I'm very proud of your decision today in delaying it. Has nothing to do with the issue itself. But as I sat there and I listened to the advertisement being posted incorrectly, my first reaction was the Sunshine Law. And also my first reaction was how many times I've heard people from the Attorney General's office use Escambia County, pardon the language, as the whipping boy. Also, I want y'all to know publicly, some of y'all do know my sister. She works in the budget department. Regina Hall is my sister. So at those meetings, I have to remind them that please don't make fun of my county. My sister works in the budget department. Thank you very much for your decision today and delaying it by following the Sunshine Law. Counselor, thank you for your recommendation. I could honestly see, I'm not an attorney, but I have seen numerous times Sunshine Law issues come up. Thank you. Y'all have a great day. I'm very, very proud of your decision.
Thank you
And I
for
will
your
continue.
service to the community.
Yes, I am on the Building Code Administrators and Inspections Board, which is the board that licenses Mr. Tolberts. Mr. Tolberts, I'm the ADA representative on that board.
We know you well.
Thank
Thank
you.
you.
Thank you very much for
Thank
your
you.
service. I know y'all get paid like me quite generously. I say that punly. Y'all have a great day and thank you again.
Okay,
We cleared the room.
clear the room. Well, case number
Don't worry about it.
V 2023-02, 1841 Kingsway Drive. And where is
The applicant was
where are the
notified
parties?
that they needed to appear. So far, we haven't seen anyone. And this is one of these situations, this is a chicken or the egg situation. It's a conditional use for the property and a variance for the property. It would be the board's discretion which one you wanted to take first. They would need both, so one of them alone being approved wouldn't matter if they didn't get the other approved.
Mr. Chair,
Notice was sent to the applicant that they needed to be here.
Mr. Chairman, I don't see how we can proceed on this one. The applicant has to present the case. It's not the burden of the county or the responsibility.
Correct.
And if the applicant doesn't show up, then we can either, I would think, at least in my opinion, we can either continue it or simply drop it.
I agree. I don't think we should proceed with it. Well, I'm not gonna say I agree, because me personally, I don't think that we should proceed with this without anybody being present. If they were notified, things do happen. They could be sick. If they are sick, we can understand that. But I feel like we should drop it at this point, and unless they can come up with a good reason why they were notified and they didn't attend, I think they need to reapply, and we can look at it at that time.
We've lost,
So,
we've lost everybody.
yeah, we have.
They wouldn't
No.
necessarily have to reapply.
They wouldn't necessarily have to reapply. We would just put them off till next month. And again, remind them they have to have some sort of representation here. As
Who
Mr.
would bear
Goblin
the
pointed,
cost of the notice?
Let
I
me
guess
just
it's
say
on us. If it's the board's action to move it to the next month, then the county will pay for the notification requirements. And this is for both the variance and the conditional use. And as Mr. Godwin pointed out, I know sometimes applicants like to defer to the staff, but it's not our case to make. It's their case to make. We have findings that are separate.
We need a motion to ask this applicant to reapply on both the
Well, for-
variance and
Oh.
conditional use.
Mr. Chairman,
Yes.
our attorney said the applicant didn't have to reapply, but, my concern is, who's gonna, front the cost of, them coming back next month? If they do come back, because I don't think it's, fair for the citizens, you know, that have, you know, their tax dollars to have to pay for the cost of them coming back because they didn't show up.
So if he reapplies, does he
So-
have to pay the fees?
Okay, she
or-
said they don't have to reapply.
Okay, so we
They-
can,
Correct. There would be no fees. It's just a matter of the advertisement.
Yeah.
But this applicant didn't show even though,
Can we put it off for 2 months and give the applicant, time to pay for the advertisement if they wanted to continue with it at that time?
Yes. Right. Okay, so, Rachel's telling me the mailers, the ads we're already gonna be running an ad, so that wouldn't factor in. It's approximately $30 a mailing cost. It would need to be borne, I'm assuming at your wish, by the applicant.
Yes, yes.
Yes, sir.
You know, if they could, if it's fair to make a motion for them to come back next month and, for it to be advertised at the $30 cost of the applicant, and, that way the taxpayers don't have to, take care of that cost due to their absence today.
is there what's the timing on the advertisement? I mean, if we don't contact him for 2 weeks,
No, it's 15 days prior,
15 days, so he has to,
early next month.
he has to contact,
Oh, we'll be reaching out as soon as
Yeah.
we leave this meeting
Yeah,
again.
yeah.
Absolutely.
yeah, but if it doesn't happen before the notice, then it's gotta go another month.
But again, if I understand what Andrew has said, he's not been in contact with the
Right.
applicant with any kind of excuse or explanation or anything like that. So I also of the opinion that we, the taxpayer, shouldn't fund a situation where a do-over in a case like this. So, Mr. Chairman, I would second the motion if there hadn't been seconded.
we have a motion.
Drew,
by
Drew,
Willie.
do you want the board to specify a date certain that it will be rescheduled? Or would you rather the board simply make a motion to allow this to be rescheduled, subject to the applicant's availability?
That might be, yes, thank you. That might be better, just because we don't know what the situation is.
Yeah. And do we need to include in the motion that it has, in order to get on next month's schedule, it has to be done by a certain time, the notification, because
Correct.
if
We
he
would,
drags out, then it's the following month. So how
Well-
do we get that in the motion? Just,
what we would do,
Put it in.
and I'm not sure how to put this in a motion.
I think just a motion to reschedule these two cases, the variance and the conditional use, subject to the applicant's availability, which staff will coordinate, and contingent upon the applicant covering the cost of renoticing the
Yes.
hearings.
That's the motion as I understand it from Willie, and seconded by Michael. Any further discussion? Seeing none, those in favor signify by raising your right hand. Passes unanimously.
Good job, Willie.
Yeah.
Rochelle, that's what you get for telling us there'd be no meeting next month.
Okay, so there's your future business. We're going to have a meeting next month, the 21st.
Any counselor comments?
No, other than, there was a remark at the last meeting relating to the first case to allow on-premises alcohol consumption within 1,000 feet of a place of worship. One of the speakers who came did comment that they intended to appeal the case. I believe that timeline expires this Friday, and as of yet, I have not seen anything, and I don't believe the clerk to the board has either. So just an update on that.
That, as a comment to that, that guy put up the fence that put up the fence that the church said they got their denial or got his approval.
Yeah.
Yeah, but yeah, church said the fence didn't matter, but he put it up anyway.
Yeah.
There aren't any more legal issues out there, are there? We don't have any more cases?
There are not any appeals pending at this time, I don't believe.
No. The only thing that's been hovering was beach access, but that's been
That's been
resolved.
resolved, yes,
So, in the county's favor.
yes.
Yeah.
Well, the next meeting is June 21. And after 16 years on the board, this is a new one on me.
Same here.
Be there. Or be square.
Yeah.
Mr. Chairman, I guess we're adjourned.
If there's no objection, we stand adjourned.
Good.